Hello, everyone. We are going to talk about consideration in contracts. So, while we're going through this handy dandy PowerPoint, what I want you to do is make sure you have the consideration worksheet with you. It has two different columns, and we're going to fill that out, and that's going to help you a lot. So, as we know, in order to have a contract, we need an offer and we need acceptance. And once we have that, we still don't have a contract if we don't have consideration. And I want to just really give you a very simplified version of consideration, okay? Consideration is something for something, okay? Sounds easy, right? But that is what distinguishes a legally enforcement agreement, a legally enforceable agreement, which is a contract, from a gratuitous promise or a gift. Okay? So consideration is what distinguishes the enforceable agreement from a gift or gratuitous promise. So I have my handy dandy remote control and I would like to give it to you and you accept. We have an offer and acceptance. But what don't we have? We don't have the something for something. So we have a gift. We have a gratuitous promise, okay? I would like to sell you my handy dandy remote control for $3 and you agree, offer acceptance. And this is a legally enforcement agreement because it is consideration, okay? Consideration is what distinguishes. Now, we could make it easier and leave it at that, but that's not what the law is. So, to have consideration, you have to have two things, legal value and a bargain for exchange. Okay, and I'm going to break those down hopefully as simply as I did the something for something. Legal value. Basically, legal value is I'm going to do something for you that I have no duty to do. Okay, I don't have to give you my remote control, but I'm going to, okay? And you're going to see the second half of this is it has to be that you're going to do something for me. But we first look, do I have something that I don't have to do? Give you my remote control. Do you have something? Yes, you don't have to give me $5. You don't have a legal duty. You don't owe me $5, right? So we're both doing something we don't have to do. The other way is we could refrain from doing something that we had a legal right to do. And we do this and we think about lawsuits, okay? So it's called forbearance. If I have a legitimate lawsuit that I can file against you and I agree to refrain from doing so, if you go ahead and settle with me for $1,000, what do we have for consideration that's legal value? Well, I have a right to sue you if it's a legitimate lawsuit, and I'm not going to do that. And you don't have to give me $1,000, but you're going to. So we each have something of legal value. So when we talk about the legal value, doesn't matter that I sell you this for $20. You agree. I'm going to give you my remote control, which I don't have to do. You're going to give me 20, which you don't have to do. We each have legal value. But can you argue after you've accepted that $20 is a lot of money? I don't want to do it because it wasn't enough. I got a bad deal. Well, the courts say no. Because if you can understand a deal or an agreement, sorry if you make a bad bargain, but consideration, it does not fail for inadequacy. The only way is if we have something that's fraudulent or we're trying to make something seem like a gift when it's not. But if you got a bad deal, you're stuck in that deal. You agree to pay something, you're stuck, okay? You can't come back and later argue, well, that was way too much money, judge. The judge is still going to enforce that agreement. So what if I want to add some terms, but we are already in a contract? Well, it depends. So we're still on legal value. Here, I should have told you, and I apologize. Legal value is written on one side, and that legal value is what we talked about. You're doing something you don't have to do, or you're refraining from something you're allowed to do, okay? What if I add terms? We already have an agreement. Well, if it's common law, you're going to have to give me something in exchange. So I agreed to paint your house for $500. We're talking legal value just at this side right now. You say, okay. The legal value is I don't have to paint your house, but I'm going to. You don't have to give me $500, but you agree to. So we have legal value. But the paint turns out being more than it's supposed to. So I come back to you and say, I can't do it unless I do it for $700. Well, we already have an agreement. So you say, no, you said $500, we had an agreement. The only way I can change and add terms is if you're getting something in return. Otherwise, you can tell me you're going to, yeah, I'll pay you $700, but when I'm finished, the courts are only going to make you pay me $500 because that's what our agreement was, okay? Let's say I come to you and I say, hey, would you like to use the premium paint? Because when I talked to you, our $500 agreement was for the standard paint, and it would be $100 more. That's new consideration. You're going to pay me $100. I'm going to give you premium paint. Okay? So that is new consideration, and that's valid. Now, under the UCC, which we're talking about goods, right? Movable, tangible goods, you do not need new consideration. If the parties agree to change or add terms, the courts will honor them if they can show there was an intent and they were bound to be so. But let's talk about common law. If you already have a duty to do something, sell you the house at a certain price, perform a service at a certain price, you have that duty to do, you cannot use that as new consideration. So let's take a look at an example. So we have an employer that hires an employee to work as a commercial salesman. And the employee had worked there for 5 years at will, meaning he could be terminated at any time. But he has established this good customer base, the salesman has. And the employer becomes concerned because if that employee leaves, guess what? All his contacts may follow him. So the employer says, guess what? Hey, employee, would you sign this non-compete agreement? And the employee says, okay. Well, the employer is kind of a snake because what he didn't tell him is that there was going to be a new sales compensation schedule and we're going to reduce your commission by 25%. So, of course, one of the reasons he wanted to sign the non-compete is, hey, you know what? Once we get this new thing in place, he may leave. So anyway, the employee said, I got to go somewhere else. I got to make money. So he goes to get employment elsewhere. And the employer discovers this and that he was going to go to this new employee. And so the new employer hires him. And then a letter is sent saying, hey, you can't hire this guy because we have a letter of non-compete and he can't come. So the new employer fires the guy. And then the competitor doesn't, another competitor doesn't hire him. And basically the employee can't find a similar position because of the non-compete. The employee comes back and he says, wait a second, you know what? I shouldn't have to go by this non-compete because yes, it was an agreement. They said, will you sign this? I signed it, but there's no consideration. And remember, we need something for something. And the Washington Supreme Court said, well, look at this. Here is the deal. If you're going to force someone to sign a non-compete once they're already employed, you got to give them something. You have to say, hey, we're going to give you additional training, or we're going to promise to continue to employ you for a certain amount of time if you sign this non-compete. But the guy wasn't getting anything in exchange for signing it. So they said that is lack of consideration. You already gave me my job. I already have my job. So you're not giving me anything more than I would have anyway. And yet you want me to sign this non-compete. So it was invalid for lack of consideration. The second thing you want to put is bargain for exchange. And what is the legal bargain? So how we do this is we say, what were you giving And what were you accepting? And were you doing it for inducement to get it? What does that mean? Here's consideration. What am I getting or giving up? $500, I'll paint your house. Okay? I am going to paint your house. That it has legal value because I don't have to. You're going to give me $500. That has legal value. But how is it bargained for? Well, you just asked this question. Is the reason I'm painting my house because I want $500? Yes. Is the reason you're giving me $500 because you want your house painted? Yes. That's bargained for. Doesn't mean we have to bargain or anything. It means we're both doing it because we want from each other what we're getting. So here's an example. There were these inauguration tickets for Obama, and basically they offered them to the public. And there was no charge, and interested parties just said, call your congressperson. So Steinberg contacts congressman, and he's told, hey, come get the tickets at the congressman's office. And so Steinberg goes to the office and he gets these tickets, and he ends up flying to DC from Florida with a friend, and he arrives several hours early. But guess what? There are too many people, he can't come. So he wants to sue the government for breach of contract. But the United States says, what are we getting in return? We gave you these tickets, right? We did not get anything in return, so there's no consideration. This is merely a gift, right? This is what makes the difference. So in determining whether there was consideration, it's not whether one party received a benefit, but whether the benefit was bargained for, meaning, did I do something for you so I could get something? And what Steinberg tried to argue is he went to the congressman's office to get the tickets. Well, the congressman didn't give him the tickets so that he'd come to his office. He didn't want or care if the guy came to his office ever or who came to his office, right? He gave them to him as a gift. So that is the difference. The reason he came to his office was just so he could pick up the gift. There was nothing that the congressman was getting in return. And so there was no consideration. So to wrap it up, we have legal value on one side. Remember, that's I'm giving up something that I don't have to, or I'm not doing something I'm allowed to. And bargain for exchange is the because. Why am I getting what I'm getting? Why are you getting what you're getting? We're doing it because we want what each other has. So I hope this helps. Take some notes on it, and it'll be great for your quiz.